I'm not an attorney. This is not legal advice. Expose Evil here. Like, share, subscribe. Today I'm doing a video to show you how powerful this case actually is. And know that this is the law of the land. This is the Supreme Court, 597 U.S. 1, 2022. Real quick about the case. It's about two members of the New York State Rifle Pistol Association being denied for their unrestricted concealed carry license by Kevin Bruen, the superintendent of New York State Police. So basically, they brought suit against him, and the result of the case was that there must be a historical tradition of 1791 for the laws now to be valid. So this literally struck down over 100 years. They had this, concealed carry law that got struck down by this case. So, attorneys for Hunter Biden have filed a motion declaring that a law preventing drug users from buying and possessing firearms is unconstitutional. Biden falsely certified to the ATF on Form 4473 that he was not an unlawful user or addicted to drugs. The third count charged that Biden illegally possessed the Colt Cobra 38 SPL revolver from October 12, 2018 to October 23, 2018 for 11 days while knowing that he was an unlawful user of or addicted to drugs. The defendant asserted that the third count charged under 18 United States Code Section 922G3 doesn't pass constitutional muster, and because of that, the first and second count should be thrown out too. Mr. Hunter doesn't only cite the new Bruen law, he cites United States versus Daniels, 2023. In this case, they struck down the same federal law from Title 18, United States Code Section 922G3, that says it bars an individual from possessing a firearm if he is an unlawful user of a controlled substance. Patrick Daniels is one such unlawful user. He admitted to smoking marijuana multiple days per month, but the government presented no evidence that he was intoxicated at the time of arrest, nor did it identify when he last had used marijuana. Still, based on his confession to regular usage, a jury convicted defendant of violating Section 922G3. The question is whether defendant's conviction violates his rights to bear arms. The answer depends on whether Section 922G3 is consistent with the nation's historical tradition of firearm regulation required by the Bruen versus New York Supreme Court case, right? The Fifth Circuit reversed the judgment of conviction and rendered a dismissal of the indictment. The court explained that the nation's history and tradition may support some limits on an intoxicated person's right to carry a weapon, but it does not justify disarming a sober citizen based exclusively on his past drug usage. Nor do more generalized traditions of disarming dangerous persons support this restriction on nonviolent drug users. Thus, the court held that it applied to defendant. Then Section 922G3 violates the Second Amendment. Now, this is what I've been saying over and over in these cases for criminals. Instead of saying that Title 18 Section 19.2 violates or is unconstitutional on its face, they're just saying it's unconstitutional as applied to that man, or as applied to me. This is unconstitutional. I think that's the wording or the way you will go about it. Now, the first one, if I'm not mistaken, was Range versus Attorney General of the United States, and it held that 18 United States Code 922G violated the Second Amendment as applied to him. Right? He was the first one to say that it violated his Second Amendment rights that applied to him. So it said the section prohibits firearm ownership by any person who has been convicted of a crime punishable by imprisonment for a term exceeding 1 year, the federal definition of a felony. Now, all he did was lie on a form to get food stamps. But it doesn't stop there, as you've seen with Daniels. And then even drug dealers are getting their case thrown out. Like we see with United States versus Quoles, he was a 3 or 5-time convicted drug trafficker, and he was still on parole while he had got caught with a gun. And they did bring up the fact when he tried to use Range that he was very different from Range in charges. But it still was. The threshold question that must be addressed is whether Corliss is one of the people protected by the Second Amendment despite having prior felony convictions. And they're citing Range, right? And Corliss asserts that he remains among the people for the Second Amendment purposes, and the government does not disagree. And it's funny to take note that it said, interesting to note that the government argued in range that dangerousness is not a touchstone for the historical analysis, right? The historical tradition analysis required by Bruen, whereas it asserts the opposite here. So they try to change it up against Corliss, but they end up dismissing because they couldn't meet the burden of the historical tradition. And before those, we had United States versus Price, 2022. It found that 18 United States Code, Section 922K, was unconstitutional. The court noted that serial numbers on the firearms did not exist in 1791 when the Second Amendment was ratified, so a prohibition against removing them is not consistent with the historical approach to the Second Amendment. And even in Rigby versus Jennings, a federal judge in Delaware struck down provisions of Delaware new ghost gun law that prohibited distribution, possession, and manufacture of unserialized firearms. And the United States versus Rahimi. You can look this one up yourself. He was arguing with his wife and fired his gun in the air when someone approached him when they were in public. And he owns an AR-15 rifle and a pistol. And he was put on a restraining order from his wife. I think he even threatened his family, his wife, like to bodily harm. And it still was held that they cannot disarm him while they cannot take away his Second Amendment rights just because he's on a restraining order.